Matter of Friedman v. Rice. Counsel.
Good afternoon. May it please the court. My name is Ron Kuby. To my left is my associate, John O'Brien, and to his left is my associate-to-be, Rhea Trivedi. And this case presents two questions that I'm going to address primarily.
Counsel, do you want to reserve rebuttal time?
I'm sorry, Judge. 3 minutes, please.
Yes, you have
Just so excited to be here.
We're happy to have you.
Thank you so much. First, whether the Second Department's sort of unique jurisprudence in this area, which holds that anyone who gives information to the police in the course of a criminal investigation is either a confidential source or that information is deemed confidential for purposes of FOIL disclosure unless and until those individuals testify as witnesses at trial, whether that was error. And second, whether this court should affirm Justice Winslow's finding of good cause under B2B after he reviewed the documents and made specific factual findings about the contents of those documents.
We have to find that either all of the documents here are foilable or none of them are foilable, or could we do something more along the lines of the federal law where we talk about whether there's an express or implied promise of confidentiality?
Well, yes. I mean, you could do that. I'm just not quite sure what the mechanism of doing that would be for this court, because remember.
Well, we wouldn't necessarily have to. Once we say what the test is, then a different court could actually look at the documents themselves and see whether they fit. For example, and this is just one example, it could be that there's implied confidentiality for witness statements that disclose very personal and private and intimate acts of a sexual nature. And maybe those are protected, and others, for example, where a witness said, nothing happened to me, I didn't observe anything, and maybe those wouldn't be protected or excluded or exempted under FOIL. So
The problem that I have at this point, given the procedural posture of this case and the fact that we filed this request on September 19th, 2012, the purpose of FOIL is to provide fairly expedient process in getting these documents, and now we're here and we're talking about a remand because the DA's office specifically adopted a test for confidentiality that is not accepted anywhere except inside the Second Department. There's even a question as to the Second Department's own jurisprudence.
Well, then are you arguing or advocating for whether it's the federal rule, or you can tell me if you think that the other departments have a different rule from the federal rule? What's the rule that you're advocating for?
The rule I advocate is the rule set forth in Londano.
So the federal rule. So let me ask you this. Do you think the other departments, their rule, not the Second Department, first, third, and fourth, their rules, if you think there's more than one, or if you think they've coalesced to one rule, is it significantly different from the federal rule?
I think that all other departments, either in words or in substance, have adopted the federal rule. I think the First Department has done so explicitly in Matter of Johnson and specifically rejected the position the DA's office is proposing here. The Third Department, while not specifically articulating the test of Londano, has essentially applied the test in Londano, and did that in Carnival, Gomez, John H. If the Third Department's view was that everything given in the course of a criminal investigation was confidential or the sources were confidential, John H. would have come out, I think, very differently. It was a prison context, and the Third Department in many ways has the most robust jurisprudence in this area because of all the prison-based Article 78s. It has never, and the Fourth Department in Brown versus Amherst, if in fact the Brown versus Amherst court felt that all of the documents generated in the course of a criminal investigation were confidential sources or confidential information, it would have been different.
So if we agree that the federal rule is what the other departments have applied and that is the appropriate way to construe this exception under FOIL, do we have to do anything other than reverse and send it back to the second department to apply the correct rule. I understand your point about it's 2017, but
Well, of course, you're the Court of Appeals. You don't have to do anything, or you can do anything you want. But I think that there's some sound
claim
reason.
there's error, and the question is, we agree with you to this extent that the second department applied the wrong rule, and we adopt the rule that you are advocating for, or another rule other than what the second department applies. Do we do anything else other than send it back to the second department? If you're advocating for something else, this is your
Yes,
chance.
I most certainly am, and I'm sorry if I'm not clear. At no point in the 5 years of the history of this litigation has the Nassau County DA's office offered a scintilla of proof or suggestion that any of these people involved in the case, any of the people who gave statements to the police, gave confidential information or were confidential sources. At no point have they ever indicated that any of these individuals were operating under express or implied promise of confidentiality, except their own sort of unique notion that anyone who talks to the police department expects confidentiality, which is an expectation that is belied by law.
So if it gets sent back, let me just stay with this, and then my colleagues obviously have many questions to ask. If we were to agree that it's an incorrect rule, and we were to send it back, are you arguing that they would not have an opportunity now to make a showing under the proper rule, that they're foreclosed from that? They have got to deal with whatever record they've established to this point?
I think that if, in fact, any of these witnesses were given an express or implied assurance of confidentiality, without a remand, they could still go back to Justice Winslow and say, wait, we have 4 documents here out of the 10,000 that you should protect. I'm sure Justice Winslow would grant that. But to remand it back to basically reset the clock and start this process again, I think is a mistake. And to avoid, with all due respect, to avoid deciding the good cause issue, which the second department decided not to decide. So we go back to Justice Winslow, and then what, you remand back to the second department to decide good cause? As you know, I am old. I'm getting older. I don't know if we have time for that much litigation.
Counsel, does it matter that the record below was established with the stare decisis established in the second department and the rules that were in place then? And if we change the rule now and we set a different rule, shouldn't your opponent have an opportunity to go back and redevelop a new record based upon the rule?
Of course. But how is that done in a way that's most expedient and efficient to the fair administration of justice? You tell them, with all due respect, what the new rule is, which is in fact the old rule that we've been living by for decades throughout the United States and throughout 3 departments. You tell them what the new rule is, and of course they would, of necessity, without a remand, but of necessity have an opportunity to go back and say to Justice Winslow, wait a second, there's a problem here, don't disclose these small categories of documents, and here's our evidence. But to simply remand it back for them to begin this agonizing, time-wasting process over again simply ensures that it's going to be more years until this is finally resolved.
To go, I think, back to something Judge Stein was asking earlier, counsel, what information's actually here? There seems to be some confusion as to the initial FOIL request, then what went into the court, and then a little bit about what went up and what the appellate division actually ruled on. So what's your view of the universe of information we would be applying this rule to, or we would be saying you apply the rule to when we send it back?
Well, it's hard to know what we don't know. Fair enough, but we do know some things. We do know that there are the statements of complaining witnesses, and that were given, according to Justice Winslow, that vary dramatically, both from account to account and individually from witness to witness, depending.
Understood those statements. What other types of information?
The many statements we anticipate of individuals who were in the classes, and reported to the police that, in fact, absolutely no sexual abuse took
That was
place.
17 of the 25, right? Sorry for interrupting. Wasn't that 17 of the 25 that reported no abuse?
There were, I think, substantially more who reported no abuse. But again, that's what the Rice report indicated. But there were at least dozens that said there were no abuse.
So of the individuals who reported no abuse, are they considered a witness whose statement is confidential when they said nothing happened?
DA's office considers them. DA's office said every single document is protected completely by 50B2B. That's their position. I mean, and again, I can see how they could do that. They could say, well, here's the statement of, I won't even name him, and here's his statement. He said there was no sexual abuse taking place, but he mentioned specifically that he was seated next to Gregory Doe. And Gregory Doe was not sexually abused. Their position is, aha, Gregory Doe is a sex abuse victim, and therefore they're going to exclude that statement, not redacted, even though they have redacted versions. They're not going to include that because it identifies Gregory Doe by name, even though we've had Gregory Doe's name, actual name, for 30 years, and he participated in capturing the Friedmans in sort of a starring role.
Two questions, just to clarify. First, the documents they're requesting, you're going back to the original FOIL request, I thought, was everything that the DA's panel had reviewed. Is that correct? Plus, all records supporting any determination that the members of the panel are not what's called members of the general public for FOIL or 50B purposes. That was what was originally requested?
Not precisely.
Okay.
We
What am I?
asked
Just tell me what I'm missing.
Sure. We asked for all documents that were provided to the Friedman case review panel, and I believe that was our language. We subsequently found out that there were two very different entities. There was the advisory panel that was provided one set of documents and summaries in redacted form by the DA's office, and the Friedman case review team, which consisted of, as we have been told, senior experienced assistant district attorneys.
Let me ask that. So is that the basis of some members of the panel saying that they were not given all the documents?
Yes.
Is that your sort of argument? Okay.
Yes.
Second question is when it went to Supreme Court, did Supreme Court, the court itself, ever do a review of all the documents?
Yes, it did.
It did an in-camera review?
That's my understanding, that it did an in-camera review of all of the documents with the question that was left open of whether Justice Winslow actually viewed and reviewed the grand jury minutes, and that was never adequately determined.
Well, I saw that the law clerk, was that her law clerk that?
Yes, Judge
made a statement?
Bachman's law clerk, Scott Banks.
I see, but there wasn't, in other words, we don't know if Supreme Court did an in-camera review of the grand jury minutes then?
We do not.
Okay, thank you.
And that
Counsel,
remains an open
your
question.
light is out, but do you want to take 30 seconds to address the grand jury issue?
Yes, and I'll do so in 30 seconds.
You have rebuttal time on.
Okay. If we have not made out a case of compelling and particularized need in this case, then I really don't think any non-governmental entity will ever achieve that.
As I understand the particularized assertion, a particularized showing, it has to do with the fact that the grand jury minutes could reveal that the techniques that the police used in questioning the children at issue were invalid. Is that correct?
Not entirely, but...
Is there some other assertion in your
Yes,
brief?
I mean, what the grand jury minutes do, according to our expert in this area, Kenneth Lanning, is they provide sort of the final statement that the children, now adults, made after this entire process went on as they revealed more and more, or made up, as we contend, more and more fantastic scenarios. And our expert Lanning said that, look, it's very important, as we demonstrated, I think, with the Fred Doe disclosures that we in fact have. It's very important you start at the beginning, first disclosures, and you examine each all the way to the end. The grand jury minutes, in essence, would be the end point for our purposes.
So is this evolution of the way the story of the victims unfolds? Is that what you're trying to say?
That's correct. How a child, in one case, at the very beginning said, nothing happened except Arnold would give me bad hugs. And over a period of time, through repeated investigations, that child maintained that he was repeatedly and publicly...
At the point of the grand jury.
Correct. And that would be the sort of end point. Now, look, could we reverse engineer and guess at this? We probably could, based on the counts, but we have no other way of getting that final information.
Counsel, the question, if you would, with respect to the grand jury minutes. I can see, I think, seeking the grand jury minutes for purposes of maybe an insufficiency of the evidence argument. But we're here on actual innocence. And those seem to me to be two different things. And so you're looking for factual proof of actual innocence, not necessarily to try and find out what evidence was before the grand jury and how can you degrade that in your argument. Do you follow my question? And I'm wondering why could you not have the same result here without the grand jury minutes by looking at the indictment and the allegations in the indictment and the information that you already acknowledge that you have?
And again, the only answer to that is simply by completeness. If there were 10 statements given under various forms of examination, and we have 9 of them that changed, each one being different, it would be very good to have the ultimate statement, the 10th statement, which appeared before, which was contained in the grand jury minutes, to find out what they ultimately and finally said.
Okay, thank you, counsel.
Thank you.
Rebuttal.
May it please the court, I'm Judith Sternberg of counsel to the District Attorney of Nassau
Can I
County.
just start with one question, sort of where we left off on the grand jury minutes, so I don't forget?
I don't want to forget either.
My question is, if we were to find that there was a compelling and particularized interest sufficient to disclose the grand jury minutes, would that in itself answer the question of whether there's good cause under the civil rights law?
Well, compelling need is certainly a stronger term than good cause, but the considerations are different. One is considering the significance and public interest of the secrecy in the grand jury, and the other is considering the privacy needs of these specific sex crimes victims. But when I said I didn't want to forget either, what I meant was I didn't want to forget to answer the question concerning whether the Supreme Court had the grand jury minutes. The Supreme Court did not have the grand jury minutes. The district attorney was ordered to supply specific materials and inquired.
I had asked a question. So in the record, you're saying it's clear that they didn't review the grand jury minutes?
He didn't have the grand jury minutes, and he said he didn't want the grand jury minutes provided to him.
I see.
And it is not impossible that there could be some case somewhere.
Do we have to send it back so somebody actually looks at it?
If they're going to be disclosed, most certainly, because this court, aside from the fact that there was no particularized need, there was no showing that these minutes are essential, and there was absolutely no attempt to minimize the invasion of the grand jury.
So you would have to remand to see whether there are other informational, you would have to remand to figure out whether there are other available sources.
Absolutely, Your Honor. But even then, the petitioner would have to establish that his interest in getting these minutes overcomes the privacy interest and the secrecy interest in the grand jury proceedings, and that is...
Well, why doesn't the expert's affidavit do that?
Well, it doesn't do it for a lot of reasons. But one of the most significant is that what he wants is more. Petitioner has already told the courts below concerning his actual innocence hearing that he has enough.
But isn't that, well, he didn't say he has enough. He says
actually
he has
said-
some, but isn't that suggesting that the less you have, the more you can show a compelling interest? I mean, there's
Well,
some
if
interesting
you have
results
made
that
no
could...
attempt to provide your own and find your own evidence, then
Well, we're talking about a lot of years after these events. I mean, this is a pretty unusual circumstance, so.
it's a very unusual circumstance, Your Honor.
By the same token, many of the reasons for grand jury secrecy may not apply as strongly here.
I can't agree with that, Your
Well,
Honor.
what
Well,
about the, what
you
about the?
concede that there's only actually one of the 5 that's been
Oh,
identified that applies here,
Yes.
right? Which is you don't want to
But
discourage
that-
people, right? You don't want to discourage people from testifying at
That's
the grand
right.
jury.
And these people went into the grand jury believing, well, their parents, they were children at the time, their parents gave permission for them to testify, believing that this testimony was going to be secret, that their privacy was always going to be protected, and indeed, that
What
is
if you just
why
redact
a
the
plea was
names?
negotiated.
What if you redact the names? His point is he wants to show the evolution. What if you redact the names?
That would probably be insufficient, Your Honor, if there's other identifying information and information that refers to other students.
Well, what if you redact that? Isn't his point that he just wants to show that, I forgot the name he used, but Gregory Doe, I think. Gregory Doe says one thing this day, and over time, based on these, excuse me,
I'm
these
sorry.
investigatory techniques, Gregory Doe now has a very different, if not fantastical story that Gregory Doe has come up with?
Well, if all identification testimony could be redacted, that would be one reason that he might warrant getting the material.
Well, it's hard if no one's looked at the grand jury, right? Or at least the court has not.
Excuse me?
It's hard to make that call, perhaps, if the
It's
grand jury, if
absolutely
the judge,
impossible.
but I'm saying, if the judge has not had an opportunity to look at the minutes?
He chose not to have the opportunity to look at it.
Yeah, but now we're at a different point, right? That's sort of getting back to his
Right.
point. We're at the Court of Appeals now, right?
And he would still have to exercise his discretion. There was never...
Let me ask this, let me ask this. The Second Circuit, what, did they review the grand jury minutes?
No, you mean
No.
Second Department? No, they did
No,
not.
the Second Circuit.
Circuit.
The Second
Oh,
Circuit.
no, the Second Circuit certainly did not.
I see.
Can we go for a moment to the witnesses' statements as compared to the grand jury? Because it's my understanding, your assertion, as reflected on page 34 of your brief, is that it's reasonable for one who speaks to the police in the course of a criminal investigation to believe that the information he provides is given and received in confidence.
Yes, Your Honor.
So your assertion, as I understand it, and I believe that the DA's Association amicus brief says the same thing, that any statement any individual gives to a police agency in the course of an investigation is confidential. Is that correct?
Yes, Your Honor.
So,
Defending,
which is not, of course, consistent with the First, Third, and Fourth Departments'
Well,
interpretation,
actually-
am I right?
well, actually, the Fourth
Or
Department...
the federal courts?
No, it's not consistent with what Landano says.
But if you're right, then I'm a little confused as to why FOIL talks about identifying a confidential source or confidential information, because the word confidential isn't even necessary if every single thing anyone says to a police officer is confidential.
Well, the Second Department has not said anything they say is confidential. They've said that anything they say is confidential until and unless that witness testifies in trial, in which case, of course, any kind of confidentiality is waived. This
So
is
if someone
not-
says, so just so I understand how you define a person speaking to a police officer or investigator. So if someone comes up to me and there's an accident, car accident on my way home, and somebody comes up and said, "What did you see?" And I say, "I saw absolutely nothing. I have no idea what happened." That's confidential?
No.
Why?
And,
That's what you, page 34 of your brief articulates this confidentiality that's so broad. I'm having a hard time understanding.
Because that is, I guess I would say that in that case, the presumption has been rebutted. And although I know...
Because I didn't see anything?
Because your statement was so innocuous. And that's different from children who speak to police officers concerning
Well, let's
Allegations.
okay, we'll get to the sex crime issue in a moment, but can you just clarify what you just said? What's the presumption you're talking about? Because I thought the presumption in FOIL was disclosure. And it's your burden
presumption is
to explain
disclosure,
why
and
it's not going to
petitioner-
be disclosed.
And petitioner has alleged that the second department has created a blanket.
No, but what,
Presumption.
I'm asking about what you just said. What's the presumption you were referring to?
Well, I was referring to the I shouldn't use the word presumption, I should use the word blanket exemption, because that's the word that petitioner claims, that's the phrase petitioner claims the second department has created. But
Well, do you
The
disagree?
way I understand it, I'm sorry. you go
No,
ahead.
go, please.
The way I understand the argument is that most clearly through the dissent in the second department is that where you're saying that everything either expressed or implied is covered in a particular instance in testimony, then that in essence covers then everything, which means that the burden has then shifted from you, who's got to claim the exemption and articulate a reason for the exemption, to the party that wants the information. But the party that wants the information is caught in a catch-22 because they have no basis upon which to make an argument because they have no information. That's why the burden under FOIL is placed on you, but by providing a blanket exemption, that burden can never be met. That's the way I understand the dissent's argument.
right. But the statute itself creates a blanket exception. It's the
For what's
blanket exception-
confidential, I think we're back to
For what
Judge
is
Peters' point.
confidential.
It's a question of what's the point of that word, and perhaps just, what's the point of the word in the statute if it really means any witness that law enforcement speaks with?
Well, the point of it is to recognize how people deal with the police. People don't want to be involved.
No, but that's your rationality for your own rule. My question is, just on the plain reading of the statute, there's a word that's inserted there that you're trying to excise, or the second department apparently has excised through its construction. I'm not clear how you get around just the plain reading of this statute.
Well, the plain reading of the statute speaks of confidential information. And you don't have to construe that or apply any statutory interpretation about speaking to the police or not speaking to the police.
Well, let me
or
ask you
going
this.
to trial.
If-
This is confidential.
Following up on Judge Peters' example, if you say that an eyewitness who says, I didn't see anything, I don't know anything, that doesn't fall within the exemption, then what's the difference between that and one of these children's statements
Well,
that said,
Your
I was
Honor-
in class, I didn't see anything, nothing happened to me? How are those two statements different?
If I may retract, the children who spoke to these police officers with their parents' permission, some of them made statements, some of them were not permitted to speak, some of them said nothing happened, some of them said, I wasn't in the class.
Well, I'm asking about the ones who said
The
nothing
ones who
happened and
said
I wasn't in
nothing
class.
happened, to that extent, their parents probably, I don't know what their parents would probably have done, but the decision to allow your child to speak to the police concerning a sex crime can be compelled by an expectation that any of this will be confidential. And for
Would that apply in a
reason-
different crime? The rule that we make here will apply across the board. So this crime, the accusations can be particularly heinous, but if we're dealing with an ordinary drug case or some other ordinary kind of crime that we see thousands and thousands of, this rule would still apply to them. Would you be making that same argument?
I would not,
You don't think that the nature of the crime has prompted the argument for a blanket exemption?
well, that is not how the second department has put
No,
forward.
I'm asking you what you
But
think, what your argument is. Do you agree with that position?
Do I think that the second department applied its long-established rule in this case because they were sex crimes? Is that what you're asking me?
No, I'm asking you if you think the nature of the crime has prompted such a broad blanket exemption.
I don't. The nature, I think I'm not understanding you, and I apologize. But may I just say, it is,
Well, let me ask you this. If you've already conceded that it's not a blanket exception, because there may very well be statements that a witness or an individual, actually, in the example, your answer should have been it's not a witness, but let's just say with this, a statement made to law enforcement may not fall within this exception. What would be the other examples other than it's innocuous?
well, the appellate division itself has said
Okay.
that this may possibly be rebutted. In Knight v., I'm sorry, let me find the case.
You mean the Appellate Division, Second Department, when you say
Yes.
the Appellate Division?
Yes. In Knight v. Gold, under the prior law, they said that witness statements will not be disclosed except under the most unusual circumstances.
Okay, so what would be an unusual circumstance other than, I don't know, you said before it's benign or whatever,
An unusual
innocuous?
circumstance might be.
What would that be?
Where the witness goes and reports a crime to the police and then runs over to the Daily News office.
And is unusual circumstances in FOIL? Do we find that somewhere in the statute? That language?
No, Your Honor.
So what are we
But-
to do when it's very clear that the rule with FOIL is that the exceptions are read narrowly? And it sounds to me like that's a large carve-out to expand the exception rather than to read it narrowly.
Well, what you could do in this case is not reach this issue at all.
Okay.
Because the facts of this case come so squarely within the language of the statute concerning confidential information.
Well, you just referred to a situation in which somebody goes running to the newspaper. In this case, we have some of the witnesses who were part of a documentary that was made public, and presumably they were part of that voluntarily. So how is that different from the unusual circumstance that you just described, other than the nature of the crime?
People have the responsibility to protect these witnesses' statements under several different theories, under the privacy exemption.
Well, that wasn't asserted here, was it?
It wasn't, Your Honor.
Why? Do you
but
know why?
Because the DA's office was relying on long-established Second Department precedent.
Harder to prove the privacy exemption?
I don't think that was what came into it. I think it was simply that this was such a long-established exemption.
Thank you, counsel. I'm sorry, did you want to ask? one more
But
question?
what you're asking us to do is affirm the Second Department on a ruling of law that affects not just child victims, not just victims of sex offenses, but every single statement made to the police in the course of a criminal investigation. That's an extraordinarily broad request, don't you think?
Your Honor, I'm not asking you to affirm that specifically. I'm asking you to acknowledge that these statements come under the confidential information language. And that's all that the court need to address.
So are you arguing then that if these statements are assessed by the federal rule, the rules of the other departments, they would still not be subject to disclosure?
Absolutely,
Okay,
they
so
would not be subject to...
do we not have to send that back down so that the court applies the correct standard?
You certainly could.
Thank
Or
you.
you could determine it based on the absolute application of those words to these statements.
Thank you, counsel.
With all due respect, and I do say this advisedly, I think that, at least for me, I need a reality check. One of the things that is uniformly true in almost every conceivable case is that a complaining witness who testifies in front of the grand jury, and that testimony provides the basis for an indictment, that person legally, with the rarest of exceptions, cannot be a confidential source, cannot be a confidential informant, and whatever subjective expectation may have been created on the part of the parents, it was not one that the law in this country will ever accept. In the absence of some sort of, okay, well, we'll make you a confidential informant, we will never call you to testify at trial.
Counsel, can I interrupt for a second, though? I mean, maybe I'm misunderstanding this, but when we're talking about the grand jury minutes, we're really not talking about the FOIL request, right? And so the grand jury minutes, we're talking about CPL 19025.
Absolutely.
Right? And so it's under that framework that we're looking, and so when you're getting into the confidential argument, I feel we're slipping back into the FOIL language.
Yeah, I am. I'm not talking about the grand jury minutes at this moment. I'm talking about the vast
FOIL.
body of documents.
Counsel, on that point, and maybe on this reality check theory, if you go back to the statute, right, if you go back to FOIL, and you talk about the federal statute and the state statute, and I think it gets to some of what we're trying to determine here in the sense of a rule, it seems to me the federal language is a little different. And the federal language focuses on the source of the information almost exclusively, right? So it's confidential source, it's information from a confidential source, whereas the state FOIL says confidential source, yes, and we could argue in this particular case where these witnesses confidential sources are not, but it also says confidential information, somewhat more untethered to a confidential source. So wouldn't an approach to this be, is this a confidential source, and in these cases, what kind of rule would you have? What's the expectation of the witness? Also, what is the nature of the information provided? And wouldn't that get to something of what Judge Peters was saying is, okay, you may have, a confidential source. Don't worry, this is all confidential, child sex crime victim. Or you may have information that in some way is confidential to the investigation, right? I mean, isn't that really the two ways you're getting at this very, which one makes this a different standard than the federal standard? I think.
Well, it doesn't have to, okay? Because your scenario, and let's take an example, federally, the FBI rolls up to a witness's spouse and says, look, we just really need to find Bill, and we need to know if he's got a gun or not. Look, you're not in this case, but we got to find him. We got to know if he's got a gun. And she says, all right, you know what? He hangs out with Joe and Sally, and yeah, he was armed to the teeth when he left here. Okay, I got it. She's not a witness. She's not going to come into the case. She may well have given that information under an implied assurance of confidentiality. But when you are a material witness, whether you saw something or you didn't see the thing the prosecution says you should have seen.
What if
But
you're going to be
let's get back
disclosed.
to Judge Garcia's. I think Judge Garcia's, unless I'm misunderstanding him, he will correct me, of course. His point is, to the extent there is some difference in language between the Freedom of Information Act and our state Freedom of Information law, does that then require a tweaking of the rule as opposed to the federal rule? That's his point, and why don't you try and answer that?
But if you tweak it, because the language is not identical, I still think you get to the same point in your tweakage, which is for it to be confidential, there has to be either a promise or the information has to be given under circumstances which imply confidentiality. And in criminal cases post-indictment, it's either going to come out under Brady or it's going to come out in the course of discovery, as it did here. We've had these names.
It would come out
on
Counsel, it
November
would come out
30th.
on one of those things, I assume, if it was Brady or not, and we're not talking about that in this context. But so the question would be, an implied, given your scenario, the person who provides information about a gun, and the other side of the coin, maybe where we have, I didn't see anything in this car accident, parents bring their child in and they say to the officers, I don't want my child talking about this, it's traumatic, I don't want them to have to testify, I don't want this ever to be public. And they say, don't worry, okay. You would agree that's confidential?
I would
Even after, they never testify, let's say they never go to the grand jury. Would that statement be confidential? Under the FOIA?
The answer to that is yes, but. Because we know in criminal investigations that the police and the DA's office are not in a position to tell anybody that this person will never have to testify.
But they may or may not be, but for that person, they are providing that information with the understanding. And if we backtrack from that and say, well, but that doesn't really matter, it's going to be disclosable under FOIL, aren't we really going to inhibit people from coming forward and believing what they're told?
Well, okay.
Even if
yeah.
it's not true.
Yeah, that is true. But there's another problem, with all due respect, in that approach. It encourages the police and the district attorney's office to affirmatively mislead witnesses as to their legal obligation.
It's not I think that statement about you can never guarantee confidentiality is if a court orders you to disclose a witness as a prosecutor, you're going to do it. So there's no absolute protection against disclosure of your name because you can never promise what a court will do. But we're talking about a FOIL obligation here and a confidentiality issue, which is very different, I think, in many respects from that issue of what can I promise or what do I have to, what caveat do I give to a witness? I mean, they could say, give the caveat, of course not, unless a judge orders me to. And then under your thing, would that be qualifying under FOIL? I mean,
Well, to
it's just
the
a
extent the
different
law
analysis.
permits, we will keep your statement and your identity confidential.
All right. That's fine, but that's not an assurance of confidentiality if we want to use the term assurance in its normal sense, not talking about the weirdest possible case we can find, because the legal obligation in the society that we all work under, which is why we have a subpoena power and they can send nice people with automatic weapons to collect people.
Well, then what would be confidential then under your?
What would be confidential are...
If that sounds like an express assurance, if that doesn't count, what would?
Either A, and presumably the legislature...
Written agreement?
Yeah, when the legislature, by the way, and I know my time is way over, but
No,
just...
continue. Answer, please, no. Answer, please.
Yes, that in 1974, when FOIL was passed, the presumption was against disclosure. There were 6 specific categories of information that could be disclosed. And the DA's office then, just to make extra sure, even though their investigatory file wasn't one of those available to disclosure, they also got written into the 1974 version that, by the way, just in case anybody goes crazy, the investigatory file, the entire investigatory file is exempt. 1977, over the District Attorneys Association protest, the statute was amended. And by the way, Gold v. Knight was decided under the old statute. The new statute reversed the presumption, provided 6 areas of exemption, now up to 9, to address the DA's office concerns, which were threatening an ongoing judicial proceeding, life and safety of a witness, and confidentiality. So presumably when the legislature changed that whole scheme to give us the law we had now, when they used confidential source or confidential information, they did it in accordance with what this court has held in Gould, that words mean the things that they say.
Let me just ask you this, since you mentioned that particular amendment. At the time, did the Freedom of Information Act only say confidential sources? Was the legislature aware of this difference at that time?
Well, the original law made no reference to confidential sources or confidential information because it gave a blanket exemption in 2 different ways to the district attorneys and the police entire
I mean,
investigatory
the Freedom
file.
of Information Act.
Oh, under FOIA.
The difference that Judge Garcia has referred to.
You know?
You know. If you don't know, you don't know.
You actually caught me with something that not only don't have an answer to, I can't even make
It's
up
my
one
red letter
credit.
day then. Let me ask you one other thing, because your red light is off, just again. Do you know whether or not the federal courts have applied the exemption to confidential information, not just sources? Is this twice I got you?
Yeah. You want to ask me one other thing, and then I'll leave?
No. Your time is up. Thank you.
Maybe I'll leave now then. Thank you so much.
Thank you, Counsel.